Hello and welcome to the Kenneth Vercammen Law Office Legal Podcast. In this edition, we look at the 2009 changes in estate planning, wills, and probate. Now, 2008 had a major New Jersey Supreme Court case called the Estate of Madeleine Stockdale. In that case, a neighbor encouraged an elderly nearby neighbor to change their will, make them the beneficiary, and also transfer a house for below market value. The Supreme Court indicated where there is a confidential relationship coupled with suspicious circumstances, undue influence is presumed, and the burden of proof shifts to the will proponent to overcome the presumption. In addition, if there is undue influence in the making of the will and the transfer of the deed by the persons in the confidential relationship, this could subject those persons to punitive damages in some instances, plus voiding of the will. The name of the case is In the Matter of the Estate of Madeleine Stockdale, docket A-121-06. Now, the New Jersey legislature has adopted a new probate law, and some of the changes in the new probate law are very important. For example, Senate Law 708 made a number of substantial changes to the provisions governing the estates and trusts in New Jersey. Let's see, and a small example is the word testator now means both male and female individuals, removing the term testatrix. So, form wills used by attorneys need to be revised. The law also clarified situations where writings that are intended as wills would be allowed, but this requires a burden of proof on the proponent to be by clear and convincing evidence. This also requires an expensive complaint in order to show cause to be filed in the Superior Court in a hearing in front of a Superior Court judge. So be careful, have a will properly prepared by an experienced attorney. Now, under an old probate law, there was a requirement for one of the two witnesses to go to the court and appear in the surrogate's office and sign an affidavit to certify they were a witness. This often created problems when the witness was deceased, moved away, or simply could not be located. Some witnesses would require a $500 fee to simply sign the surrogate papers. The New Jersey legislature later passed a type of will called a self-proving will. And therefore, the person signs, the two witnesses sign, and then the attorney and notary signs with certain statutory language indicating the will is self-proving. When done properly, the executor does not have to locate any of the witnesses. This usually saves time and money. If the will is not self-proving or you are unsure, schedule an appointment with an elder law attorney. Some law offices ignore the revised law and fail to prepare self-proving wills. Now, the new probate law did not change what is considered the elective share. Currently, a spouse who is not given money in the will can challenge the terms of the will. This is called electing against the will by the spouse. A spouse could receive up to 1/3 of the estate, even if married only 2 weeks. The spouse must file a caveat lawsuit in the Superior Court. We suggest a formal prenuptial agreement in second marriage situations. So let's say there's no will. Well, prior to 2005, when someone died, leaving a spouse and children of that marriage, the spouse got $50,000, and then the spouse and the kids split the rest 50-50. That was often unfair to the spouse. So under the new law, let's say if the children are of the same relationship, the spouse gets 100% and the children get nothing. Now, let's say that there's a spouse and parents, no children. The spouse gets the first $25,000. I'm sorry, first 25%. Let's say, and then a fourth of the balance. There's other changes under the new probate law if there is no will, but that's why people should have a will. In either way, the surviving spouse is now entitled to a greater share of the estate in the event that there are no children. Now, if someone gets married, we recommend having a will prepared. Someone could be married 25 years, have no children, but if you die, your spouse will not receive the entire estate. 25% could go to a parent, conceivably in a nursing home. What's the effect of divorce under new probate law? The new statute expanded the present law that a divorce nullifies will provisions to the ex-spouse. It also provides that a will or annulment would revoke not only the will, but also non-probate transfers occurring by reason of the death to the former spouse. Let's say accounts that are transferred upon death. However, again, we recommend a separated divorced person prepare a new will anyway. The law provides a statute of limitations for respect to claims against creditors, and there's no longer need to publish a notice limiting creditors. Now we're going to go to the 2009 increases in federal estate and gift taxes. The amount to leave someone without incurring a federal estate and gift tax was increased to $3,500,000 for 2009. For the year 2010, there's no estate tax if the person dies in that year. So the year 2010 is the best year for your rich uncle to pass away. Let's say in 2011, the amount is reduced to $1 million. For the year 2012, we're still waiting for Congress to decide. The amount that could be provided or gifted without incurring a federal, state, and gift tax was increased to $13,000 in 2009. However, the amount permitted for Medicaid transfers still remains at zero, although the look-back period was increased under the Deficit Reduction Act from 3 years to 5 years. New Jersey law requires that a copy of the federal state tax return be filed with the New Jersey Inheritance Tax Branch within 30 days. The New Jersey Inheritance Tax Return was revised in 2010. The L9 affidavit form was revised in 2007. Throw out the old forms. Even if there's no inheritance tax due, a tax waiver on the house usually must be obtained if the house is not co-owned by a spouse. Powers of attorney. There was the federal regulation known as the Health Insurance Portability and Accountability Act was adopted regarding the disclosure of health information and other information. Therefore, it's recommended that new powers of attorney and living wills be prepared to incorporate language that complies with the federal HIPAA law. And also, regarding living wills, after you sign the living will in your attorney's office, provide a copy to your doctor and family. Administering the estate probate. In a United States Supreme Court case, Tulsa Professional Collection Services versus Joanne Pope Executor, the Supreme Court held that the executor personal representative in every state is personally responsible to provide actual notice to known and readily ascertainable creditors of the decedent. This means that the executor is responsible to diligently search for readily obtainable creditors. Other duties of the executor. Bring the will to the surrogate. Usually your attorney will prepare a information sheet ahead of time. Apply for the federal tax ID number. Set up an estate account at the bank. Send a notice of probate to the beneficiaries. Usually the attorney will handle. If there's a charity, the law requires a notice of probate to the Attorney General. Then the notice of probate must be filed with the surrogate. Usually the attorney handles. The federal and state income tax returns are usually handled by a CPA. Then there's the inheritance tax return, which is due within 8 months in obtaining the tax waivers. The tax waivers for the house then must be filed with the county clerk's office. There's an informal accounting, and the law requires either a formal accounting or all the beneficiaries prepare a release on a funding bond. Contact a probate attorney for an in-office consultation for any of these issues. Contact Kenneth Vercammen's office located at 2053 Woodbridge Avenue, Edison, New Jersey, 08817, phone 732-572-0500, website www.njlaws.com or centraljerseyelderlaw.com. Thank you.